The first item on the agenda is the appeal of Building Commissioner's decision 47 Milford Street. Correct? Property owner is appealing the decision of the Building Commissioner. One, denying issuance of a certificate of occupancy. Two, revoking an issued sign permit. Three, issuing an enforcement order from the freestanding sign on the property under Linden zoning bylaw section 603C BI, which prohibits freestanding signs for marijuana establishments. What do we have here?
Thank you, Mr. Chair. My name is Attorney Blake Mensing, here on behalf of the appellant. And with me to my left is one of the principals, Todd Sullivan.
Do you have an extra pen?
Fine.
Yep.
I'm sorry, your name again?
Attorney Blake Mensing.
Todd Sullivan.
That's all. Thank you.
You're welcome.
And Mr. Sullivan, you're the owner.
I'm one of them, yes.
Thank you. So just first, I just wanted to give you a little bit of background on who I am, just to give you some information on sort of how I know what I'm talking about here. Before becoming a cannabis attorney for the past 5 years, helping people with municipal permitting, regulatory matters, and state cannabis licensure and compliance, I was a municipal attorney myself. I've also been a local regulator, so I'm certainly sensitive to the many hard hours, that you're dedicating to Mendon here. So in my capacity as associate town council to 7 towns throughout Massachusetts, I actually became the sign bylaw guy when the Supreme Court case Reed versus Town of Gilbert, Arizona came down. So I was tasked with revising 7 town sign bylaws. So if I get a little inside baseball, it's because I lived this for over a year. And just wanted to give that as the background here. So our appeal today.
I have one question.
Yeah.
The building commissioner here. Okay, sorry.
No worries. So yeah, what we're asking the ZBA to do here is, as you succinctly said, we're asking for an order to overturn the revocation of the sign permit and to make a finding that the pre-existing non-conforming sign that was there for decades is not more detrimental to the neighborhood than if it didn't have the store's name on the sign facade. So there are a couple of major issues that I'll identify, not necessarily in order of where I think they should fit, but just an order that I think makes sense for this evening's presentation. So the first issue we have is that the building commissioner impermissibly conditioned the issuance of the certificate of occupancy on us complying with his non-official order to cover up the sign. So, I had correspondence back and forth saying, the certificate of occupancy obviously pertains to the building, what's happening inside, and a sign, much like landscaping, doesn't bear on a certificate of occupancy. We made the point that the certificate of occupancy was desperately needed because you can't get through the state's final inspection process without having a final certificate of occupancy. So there are, measurable damages in terms of delay based on the arbitrary and capricious decision to impermissibly tie a sign permit or a sign being displayed with anything to do with the certificate of occupancy. So that's a huge concern. Also, I certainly understand that the building commissioner cited to, state regulations with respect to the ability to revoke a permit that may have been granted in error. But I would just point out from a business owner's perspective, when you apply for a special permit and get approval, when you apply for site plan review and you get approval, when you apply for a separate standalone sign permit and get approval, I don't think it's unreasonable for that applicant to spend a bunch of money in furtherance of what was approved thrice. So, there were plans submitted along with the special permit. There were labels indicating what would be done with the prior existing sign to say replace sign facade. So my understanding is that sign has been up at that address for the better part of 20 years. Um, there was no alteration to the structure other than changing the content of that sign. And we just think it's the very definition of an arbitrary and capricious decision to pull that rug out after, considerable sums of money were spent. There's, a permissible sign of the entity name on the building itself. The sign in question here reflects the name of the store in a much smaller format than the sign on the building facade is. So, you can see that it is a joint operation store from Route 16. I myself live on Route 16 in Holliston, so I've driven by it many times, and it's very apparent. The linguistic argument that I'm going to make has to do with the town's current zoning bylaw. So it is true that 6.03 does reference a prohibition on cannabis establishments from having a freestanding accessory sign. However, that's not a defined term in the bylaw. There's a definition of a freestanding sign. And under section 2.06 of the zoning bylaw, there is an allowed single primary freestanding sign for every business in the business district. So, again, when we as attorneys sit down to say, can this be done? You look at the rules in total. Without a definition of a freestanding accessory sign, we weren't sure what was being prohibited. Similarly, or in relation to that, this was actually a project that my clients acquired. So I didn't do the permitting the first time. So when they acquired, the host community agreement, the property, and all the pertinent entitlements such as the sign permit, et cetera, they thought, great, we're buying what the town has already approved. When you look at that lack of a definition, when you look at the fact that a freestanding sign is permitted with a sign permit, which my predecessor to my client did obtain, you're left with just the question of how could we have possibly anticipated that this revocation would be coming. The main issue that actually impacts First Amendment rights, going back to that case I referenced, Reed versus Town of Gilbert, Arizona, is how and why the town of Mendon created the sign bylaw rule that was unfortunately a little inartfully drafted with respect to a prohibition on freestanding accessory signs. What compelling government interest it was intending to protect by saying this particular speech wasn't allowed by this particular class of speakers. And that invokes, which we'll veer into a little bit of legal nerdy stuff, so forgive me for that, but I'm going to try to explain it in sort of simple terms here. So when you have a content-based regulation, what the Supreme Court says is that regulation is facing the highest level of scrutiny that the Supreme Court issues, and that's called strict scrutiny. So in essence, the government has to prove that the law served a compelling government interest, that it was narrowly tailored to advance that interest. So narrow tailoring doesn't just mean a kind of semi-restrictive way to achieve that goal. It's literally saying you must use the least restrictive way to achieve the goal. So I looked back, I couldn't see anything in town meeting or any of the meetings by planning board, et cetera, leading up to the creation of that particular provision relating to cannabis bylaw on signs. So I don't know what the stated rational compelling interest would be. I have no idea. But the issue becomes the second you regulate a class of speakers, even if the law was otherwise content neutral, you still get strict scrutiny to be applied. As some of you may be aware, ironically, there was protracted litigation at the very address next door to this property. Showtime was in battle with town for years. That case, which the town of Mendon lost at the Supreme Judicial Court level after the First Circuit Court of Appeals, the federal court, kicked it back, that was subject to intermediate scrutiny. That is a less stringent standard than strict scrutiny. And even though in that instance, the court found that the stated rationale for the prohibitions at issue in that case were valid, they still said it didn't pass that threshold under the intermediate scrutiny test, which means you have to both further an important government interest and you must do so by means that are substantially related to that interest. So the example they used was actually, again, just down the street the other way. If the drive-in were to, have a performance where there were, there was live nudity, and my understanding is that they do have, R-rated films and potentially some, live action performances, that, a liquor license couldn't attach to that. So that's a lower bar that a court on two different instances has said Mendon's bylaw failed. So what we have here, you're regulating in a class of speakers, segregating out who's doing the speaking. So that therefore becomes content based. The other point I would just make is that the Cannabis Control Commission regulations already limit in a frankly narrowly tailored way in my mind in terms of First Amendment analysis what a cannabis establishment may advertise, and that includes signage. So under Cannabis Control Commission regulations, you can't have flashing neon, you can't have cannabis leaves, you can't have things where they were worried about, I don't know, appealing to a CD element, or trying to make it just in the faces of children, things like that. That's what the stated rationale. So the sign in question here says the name of the entity, joint operations. I can't recall off the top of my head if it contains the word cannabis, but everyone who's driven by knows that cannabis is sold there. And I don't understand, there was no compelling government interest described or discussed when that bylaw section was enacted. It lacks a definition to be able to understand as an attorney, what are you prohibiting, because freestanding accessory sign isn't listed. The baseline business treatment and section 2.06 is to allow a freestanding sign. This was a prior non-conforming use. It's pre-existing. All that was changed was the sign facade. So, we have several different standards, and I know, again, this is sort of inside baseball legalese, but the standard review, of the building commissioner's decision here is one of, does it meet the arbitrary and capricious standard? So the best way to explain that is, a court won't look behind the curtain of a decision unless it's something like 1 + 1 = purple banana, right? You don't have to have substantive knowledge to say that you can't, add those things together and get a fruit, right? So in this case, we had a building commissioner in writing saying, I'm not going to give you a certificate of occupancy because your sign is out of compliance. What took over a month to secure was the actual order, saying to cover it up. That was the only permissible mechanism available at the building commissioner's disposal. That was the route. So, my client was, essentially penalized for following what they viewed to be a permissibly issued sign permit, a site plan review that included reference to the sign, as well as the special permit. So, for all those reasons, and in particular, the fact that I think just at a baseline level, and having revised, many pages of sign bylaws, that section is unconstitutional. We certainly don't want to go the route of bringing the courts in, but I don't think this is a close call, because again, when Mendon lost, the Showtime case, that was under a different, lesser standard of review. So strict scrutiny, because it's content based, is so much harder to overcome. And, absent a set of studies that show cannabis signs have some detrimental effect, which is absent from my review of how the sign bylaw came to be with respect to cannabis, you're going to lose that case. Obviously there's no sure thing, but it's not really close in my view of it.
I don't want to cut you off.
Yeah.
I'm on a plane when we discuss this. And we know that the sign bylaw has got to be rewritten,
Okay.
and we're working on that now.
I appreciate it. I can certainly go on. So,
So, we know that there's a problem with the sign bylaw.
okay.
We've discussed it.
Well, I appreciate that. Yeah. And, whatever opinion you might have of attorneys, I
How
like,
it's got written like that, I don't know.
yeah. So yeah, I, a lot of attorneys will
And we
use
know that
bluster
a lot of
and all sorts of things, but
understand.
no, that's my God's honest opinion and assessment of the facts and the
Well,
case law.
We agreed with that at the planning.
Okay. Well, I love to hear that. So yeah, I guess I would turn it over to you if you had any specific questions. But yeah, just in summary, we're looking for a revocation of the building commissioner's order on the basis of the arbitrary and capricious, conditioning of that compliance on the certificate of occupancy's issuance, the fact that we had a permit, spent a significant amount of money to build it. And again, the constitutional argument we just outlined that says, that's probably unconstitutional on its face. So, yeah, whatever questions you may have.
The way this is gonna work is
Um,
board, this board will ask any questions that they have of the applicant. And when this board is finished asking their questions, we're going to turn it over to the audience, see if they have any questions or concerns. So bear with us under those circumstances, please. To the board, because you have anything to add to this?
I have a comment. Can I go?
Oh.
This is Tom Morelli from 52 Millville Road, also member of the board here remotely. I find that the punishment issued by the building inspector really does not fit the crime. And I guess my question is denial of an occupancy permit something that's laid out in the bylaw, or is that just a remedy that he elected to pursue himself?
I have not seen any reference to a building commissioner having power to condition a certificate of occupancy on anything related to do with a sign, because obviously you don't occupy a sign.
That's what I thought. It just seems very, as you stated, arbitrary. And I find it very, I find that it just doesn't fit the crime, so to speak.
Can I ask a question? Why didn't you just get a variance for the sign?
Again, my clients purchased a project that was in
That's it.
process.
That's the question.
Yeah, I think the answer is just that we thought we were covered by having a sign permit.
Oh, okay.
Not sure why, typically a variance is for things that, can't get a permit.
Yeah.
So that's why we didn't examine it, because we had it
So-
in hand. Yeah.
Standards.
Our special permit had the sign in it too. That was approved by the planning board too. They approved the sign before we went and got the sign permit.
I know, I'm on the planning board.
Yeah.
Oh, that's right.
Did a different commissioner issue the sign permit? Or is it the-
No, same one,
Same one.
same one.
Yeah.
I mean, the planning board issued the permit, and then it's up to the building commissioner to enforce the rules, but the sign rule there is kind of two standards.
Yeah.
Like that sign would be all right, if, like you reference, if you're selling flowers, do
Exactly.
it,
Yeah. And
that sign. But you can't use the same sign. And I don't think that's a lighted sign.
yeah, it's not. No. And that
It's
language,
not gonna be a lighted sign.
It has the ability to be lit, but according to the CCC, we
Yeah,
can't have them lit at night anyway. So
Yeah.
the
Okay.
state regulates that on a.
Okay.
and that is a permissible regulation in the category of time, place, manner. They can regulate lighting, construction,
I know.
that's it. Yeah.
That would be no lights during the day and at night.
The CCC allows lights during the day, but 30 minutes before sundown, we have to shut it off.
Shut the lights up.
So chances are we won't have it on because then it looks like we close at sundown. We wouldn't want to have people thinking that, so.
Do you have any questions?
Yeah, I mean, one question I have is in terms of the sign going forward, do you have any plans to change the sign or make it alteration, just keep it, the
No.
way it is, just with the
We,
name of your entity?
we would keep it as is and as
Sign
approved. Exactly. And
But it's a lit sign with a little box underneath.
I
You
know
can put the
exactly.
letters on, like now open.
Right,
or
every day.
Around.
And certainly we would commit to coming back to the requisite board if we wanted to make a change to the sign. I think it's a nice sign. I don't think we would
Yeah,
change
it's
it.
great.
Okay.
That's why we
I
want to
think
keep
you'd
it.
have to, then.
Yes, we certainly would follow the right procedure if we ever did want to change it.
Any other questions from the board?
I just want to comment, it might be my fault that John Erickson, the building commissioner, is not here. I told him the date and it said it will most likely be August 17th, but I'll let you know. And I didn't let him know that it might not be, or I thought I was clear enough, but it might be my fault that he's not here. Just so you're aware. I am the assistant zoning enforcement officer. If that's helpful, I can help with that.
Anybody have any questions about the building commissioner not being here? Tom? Tom?
Did you say Tom?
Yes, do you have any questions that the building commissioner is not here?
Um, yeah, I mean, I don't have any questions other than the one that I asked.
You care?
What was that?
Do you care whether you?
Not really, no.
Thank you. I'm gonna pass it over to the audience. Any questions?
Well, the reason.
You
that
need to identify yourself and your address, yeah.
Sorry. Cindy Van Sled, 32 Crestview Drive. The only reason I came is because I got a letter saying that this was happening tonight. And not a lawyer. It's kind of like I get something that says there's a bylaw and they're not complying with the bylaw. So to me, there's a real disconnect. So it was interesting to hear that. Seems like the board doesn't really have a problem.
Because it's not a bylaw really, it's just what the sign says. If you're selling flowers, you can sell flowers,
Right.
but you can't put a cannabis sign.
So I guess as a resident, it just kind of disappoints me to hear that things need to really be, shorn up and.
That's why we're having to sign what bylaw rewritten.
Can I respond to that? My question, I guess, is not so much, is it okay to get away with violating a bylaw, but whether or not this punishment, this revocation of an occupancy permit is a fitting punishment for violation of a bylaw of this nature. It doesn't seem to me like it seems to me like an extreme sort of overcorrection, personally.
And I totally get that. I've built house, had people build houses for me before. And it's one of those things that's kind of what they do to ensure that it gets done. Otherwise, if the person's already in, it just kind of gets, shoved under the carpet because, just like, well, they don't pay the plumber until it's done because they might not come back. So it sounded to me like the person who I don't know decided that they would say, all right, you don't get the permit because of this. So it was kind of a way of saying this needs to be fixed, resolved, however it gets resolved before things move forward. That's what it seemed like to me.
But there's a double standard because the sign is a legal sign. Been there before, and we approved the sign. We never got into the language it's gonna be on the sign, but we didn't see that. That's a little paragraph in there, it says marijuana.
So this is a waste of time, is what you're saying.
Excuse me, do
My-
you have any questions, sir?
No, I think that.
You should do.
Sir, back here? You have any
In my
questions?
opinion, yeah, I think that the sign, that's why we're gonna rewrite the sign bylaw. We're not, we haven't.
I drove by the sign. I think it's one of the nicest signs in the whole street.
Thank you.
Yeah, I have no issue with the sign. It sounds like, at least to me, it sounds like there's two issues here. First, as Tom, as you mentioned, sort of the punishment, fits the crime. And I also share your concern about revoking, or not allowing a certificate of occupancy for an outside sign. I could get for a plumbing or electrical or other issue in the inside. I'm not sure if it's the crime either. That's one. Two, with the bylaw itself, and it sounds like the planning board is looking at it, I'm an attorney as well, and I, share some of the concerns, looking at it in terms of, strict scrutiny and constitutionality. And I think it's something, it sounds like we're revisiting as a town. So I think, there are two different issues at hand, just my thought.
I'd like to have a motion, please.
Motion.
I'll make a motion to, um, So to be clear, what the petitioner is asking for is to appeal the zoning decision, right?
Yeah, so we're asking for the ZBA to overturn the building inspector, commissioner's revocation of the sign permit and to find that it is a pre-existing non-conforming structure and it's not more detrimental to the area just because it has the name of a cannabis store on it.
Also issue the occupancy permit.
We actually did get the occupancy permit after we covered the sign. Just the issue was the delay in getting the state's inspection. So the store is open. And yeah, we'd just like to be able
Yeah,
to
cover
display
it to
it.
get it up.
Correct. Yeah.
All in favor?
Aye.
Aye. So wait, so the
Second,
motion I
second.
made, yeah,
I need a second on the motion.
Yeah, I seconded it.
okay.
I want to be clear on the motion, Tom.
Yeah,
I want
I
to
want,
state. Go ahead.
yep, I want to make a motion to approve the I'll make a motion to overturn the building commissioner's zoning decision for revocation of the sign permit. Is that good, or do I need to add to
Why?
it?
I like to state in there why, because it's kind of a double standard, because we have two signed bylaws. That kind of.
Right.
So if I may, just the end of that sentence, if I were making it, would be to allow the sign as designed and installed and just a finding that it's a pre-existing non-conforming structure that's not more detrimental to the area just because it has the store's name on it.
Can you write?
Ditto. Ditto. Dylan,
Favor?
can you make sure that my motion reflects that? Because I
Yep, it's already in
intend to
there.
make. Okay, thank you.
All good. Yep, yep.
Done.
Thank you very much.
Thank you kindly.
Appreciate it.
Appreciate your time.
One thing I'd like to clear up. You had mentioned earlier about possible penalties against the town.
Yeah, we will not be bringing suit now that we are allowed to use the sign. Yeah, no reason to.
No reason to.
Thank you.
Original planning is working with us.
I
All we
appreciate
wanted
it.
was our sign. We got it.
A lot of sign, a lot of bylaws are kind of double standard. They're antiquated.
I mean, believe me, I have PTSD of revising all those sign bylaws. So you're not alone in the state with bylaws that were way off the mark. So I certainly appreciate it.
Get on board?
I got out of municipal law. Thank you
Thank you
kindly.
very much.
Appreciate it.
Have a great night.
I know, it's like so.
We just discussed it. Planning board.
Get that all down?
Because they came to us.
We have another-
Our hands are tied. You
Yep.
can't shoot.
35 Taft,
Those
special
lines.
permit and
Double
variance.
standard. There's a special permit, Jim, for 35 Taft Ave.
Okay, this is a 35 Taft Ave petitioner
That's me.
from Gregory Buckingham.
Yes.
Would you please come up and state your case?
Yep.
Good evening, everybody. I am Gregory Buckingham. I'm the owner of 35 Taft Avenue. Also want to give a little bit of background. I'm also, as my primary residence, I'm also a general contractor licensed in the state of Massachusetts. I'm also a licensed real estate broker and also the architectural designer of the proposed project as well. I also sit on the Nipmuc Lake Association Board as well. I'm here today to basically seek a special permit and a variance for the property, for the project that's been proposed. To give a little bit of background about this project, it's been going through the town of Mendon, various departments for several months now, since the beginning of the year. I've already been through the Historic Commission, who has approved this project. I've been through the Board of Health, who has also approved this project, been through Conservation, DEP, and now here at zoning. The building department also has knowledge of this project as well. The building permit has been submitted as well simultaneously with this. It was the building inspector, that commissioner, that actually brought me here, because we figured that, not figured, but we realized that we were dealing with an existing non-conforming lot. To my knowledge, from the zoning bylaws, pretty much most of the properties along Nipmunk Pond are existing non-conforming lots due to the size of them. This particular lot, 35 Taft Avenue, which is the subject for today, is a 10,000 square foot lot, which there's some that are 5,000 square feet. There's some 10,000, some, of various sizes. Your current zoning bylaws don't have any language speaking to dimensional requirements for the non-conforming lots, which basically lands us here to have to apply for a special permit and dimensional relief, which is what I've filled out the double application for both of those, for the non-conforming lot and for dimensional relief. I also have in place currently a demo permit, septic permit, and as I mentioned, the building permit. So what I'm here today is to present basically, I've included all that in the packet, just that's why it's a large packet. Sorry for all the paper. Very lengthy, to show you that it's been approved through all those other boards in the town of Mendon. I'm hoping today that this could get approved through your board, and we can carry on with the
So at
project.
this point, you have everybody except us.
Except for you. So we're at third base here, hoping to go home. So, we, like I said, I've been through everything. I've got detailed engineer plans. I've had, Guerin and Hanlon was the engineer that engineered everything. There's a drainage plan, solution for the property. Everything has been put through, conservation, DEP. We have order of conditions. We have the NOI we filed at the beginning. And basically, to give a little bit of background, I don't know if you want to reference the plan, but really, in my mind, and I'm not just saying it because it's my project, but I'm trying my best, and I've presented this to Historic and all the other boards, to stay within the existing character of the existing house. So if you're familiar with 35 Taft Ave, there are some photographs in here of the existing house. It's the stucco building, that's a stucco house that's kind of set back from Taft Road. And what we're essentially trying to do, the quick story of it is, the lot itself is 60 feet wide, which is non-conforming to, today's frontage that's required. So with 60 feet, the hardship is it's pretty much impossible to achieve the current zoning bylaws of 20-foot side yard setbacks, because that would only leave you 20 feet to build a structure. On Taft Avenue, it's 35 Taft Ave is one of the properties that has an existing septic tank on it that was just a septic system that was put on in 2013. So with where the existing septic system is located, with the side yard setbacks, and then the amount of space that would be left over, would only allow to build a new house that would be only 10 feet wide, which, to build a 10-foot wide house in today's standard of building codes, is not practical. That's kind of like putting a trailer, basically, if you're lucky, onto a property. So there's a tremendous amount of hardship with those restrictions. So what I'm seeking for is for the side yard setback, for only one side yard setback, because we are in full compliance with one of the side yard setbacks that borders 37 Taft Avenue, where we have 27 feet and the allowable is 20 feet. And we actually have 27. The septic system kind of helps favor that side and give more setback to 37. Where we're pinched is on the 33 Taft Avenue side of the property, that right now the existing house sits at a 10-foot setback. The proposed house and addition and reconstruction, all I'm asking is to keep that 10-foot setback. I'm not asking for any more. I'm not asking to go down to 5 feet, 8 feet, 1.5 feet, anything like that. I'm asking to keep that same exact existing, how it exists today, setback. So I'm hoping that that's, reasonable and accommodable. It's the setback that was, you know, obviously at the time that the house was built. I know it's a 100-year-old house, but I'm not asking for anything more. I'm asking just to keep within that same footprint. The only thing that's really changing on the reconstruction addition of the new house is the house is just getting elongated, which in the elongated direction towards the lake and towards Taft Ave, we're also already in compliant with the setbacks. I'm not going, the rear yard setback, I believe is 20 feet. We're gonna be 26 feet off the rear. So we're more than enough than the limitation. And on the front, you have a 50-yard setback in your zoning. I'm 109 feet off of Taft Ave. So I'm double what I'm allowed. So basically, if you can, you know, visualize that geometry of this very long, narrow envelope site and the, you know, the proposed buildable house. Yeah, 50 feet, sorry. You know, what could truly be built to today's zoning bylaws or how Mendon has the bylaws for, you know, the single family residence. You could build basically on this property, a 10-foot wide house by about 100 feet, which is not a practical house. So what I'm proposing is a house that's the same exact width, which it is now, which is 22 feet. And that gives us the 10-foot setback on the side. And then it's 54 feet in length, which it currently is 30 feet. So we're basically going 12 feet forward, 12 feet back,
I'm sorry, you're looking for a house 20 feet?
22 and a half feet wide it'll be, which is exactly what the house is right now. The existing house that's in that photos, it's 22 and a half feet, the footprint. And then the depth or front to backwards from the road back to the pond is 54 feet.
Depth of the house,
And the depth of the existing house right now with the house and the porch is 30.
proposed house is
Proposed is 54,
22 feet by
54. And the existing house is 22 by 30. So it's only growing 12 feet forward and 12 feet back.
Yes, again, is what?
Sorry, what was that?
The existing is what?
Existing is 22 by 30. So the width, which is where we're pinched because that's that side yard setback to the neighboring property, we're staying in that same footprint. And the front and back we have the allowable, which we're expanding that way.
So it's gonna be uniform, you know, throughout the same, you know, setback as is currently, so it's gonna be like a straight line.
Correct.
Yep.
Yeah. So if you're standing on Taft Ave and you're looking at the house, the width of the house is going to stay exactly the same as it is now. So, you know, in my, you know, I obviously don't want to make enemies with the neighbors. They're not going to see any difference than what they see now. It's going to be set the same way off their property as it is now. The only thing that people will see as an improvement or see larger is that the house is elongated front to back, which in that direction, because of the geometry, bless you, the rectangular geometry of the property, that is allowable to go front to back because of the setbacks, and you're still well in compliance.
The house you're proposing.
That's the existing house.
Just.
The house that's being proposed is, so if you look at the larger prints, it's gonna be, I believe, towards the last page. Actually, that's the last page of the stapled packet.
The existing house. An old stucco house.
Yep, so the second page is photographs of the existing house from all four sides, and then the last page of the packet is the proposed architecturals of all four sides. So you can see it's just become linear from front to back, not anything wider.
Would any have any questions?
Question, what's the height of the existing house versus the new?
The height of the proposed is 35 in the front, and then it drops down in the back to 28. So it's a little bit smaller, shorter towards the lake because the property does have a slope to it. So it kind of, the house is stepping with the slope of the land because it has the walkout. The existing house, don't know that I have a dimension on it, but I'm willing to bet it's definitely less than 35 feet. But
I'd just say maybe 20.
maybe 28.
I know the house.
Yeah,
Like,
yeah. It is an existing 2.5-story house, so it does have two full floors and an attic space. So it is.
But we're
to-
below the allowable height anyways.
Right, yeah, and the proposed is staying at, you know, not exceeding the 35, which is your bylaw, yeah.
Tom, any questions? Tom Morelli, any questions?
I got nothing.
I was just gonna make note what's up on the screen. That is the older engineered plan of what was proposed 10 years ago. I didn't really get into that, but sorry, I should have started with that. That a little bit of history of this project is the owner that used to own this property that I bought it off of about 4 years ago had the plans to do what I'm basically trying to do. So he just never did it. So that was from 2013 that I believe this was approved by the board back then. But it was never carried out. He ended up selling the property off and I ended up coming in to buy it.
Any other questions from the board? Audience? Would you hear a motion?
I'll make a motion to approve. You got something, Tom?
I'll let you make the motion. I'll second it.
I'll make a motion to approve 35 Taft Ave special permit and a variance for a house to be going down and a new house to be built.
All in favor?
Aye.
Aye.
Thank you, everybody.
And approve the street, that's probably the,
Yeah, nice.
one of the last new houses. Houses on the street.
You don't like Dixon Street?
Oh, yeah. Yeah,
Chicken coops.
yep.
I'm glad that was short and sweet.
Thank you. Yeah, me too. It's been a long.
Putting the pool in too?
No. So that's the old design. Yep. So conservation was happy that the pool is not going in. I said, I think the pond is a big enough pool out there. We don't need to put a pool on top of that.
Good luck.
Thank you again.
Do you have anything?
The 2 sets of minutes, one of them you were
Wait a minute.
emailed a while back. The other one I haven't emailed yet. I thought I'd just include it so you have it. If you want to read over it later, we don't have to vote on it today. But the April 20th, that was sent out a while back and can be voted on today if you were ready.
Well said.
I'll make a motion to approve the April 20th minutes as written.
I wasn't there, so I can't do anything. Second.
Second.
Aye.
All in favor?
Aye.
Aye.
Is that 2 abstentions then?
That's April 20.
That was just it.
So you got all that?
And then June 15. Jim was absent. I was acting chairman, so I can't make a motion.
Make a motion to approve the minutes of June 15th as written.
I'll second.
All in favor?
All in favor?
Aye.
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 Good. Motion to adjourn?
Second.
All in favor?
Aye.
Aye.
Done.
Have a good month, everybody.
Okay, Tom.
Thank you very much, everybody.
When's our next meeting? September?
December 21st.